Judge Eileen Cannon's out with a new paperless order. Here's what she ruled. She's temporarily stayed the SEPA Section 5 and Rule 16 expert disclosure deadlines in the case. And then she writes that an order setting a second set of pretrial deadlines and hearings is to follow, signed Judge Eileen Cannon. It should be noted that she has not yet moved the trial date in the Mar-a-Lago document case, which is still scheduled for May 20th. She has now delayed or stayed the SEPA deadlines and other expert disclosure deadlines in connection with the trial. But what in the world is Judge Eileen Cannon doing here? Look, we previously reported over the weekend, and hat tip to NPR for investigating this, about Judge Eileen Cannon not disclosing lavish trips she took to a Montana lodge, which is known for its beautiful spas, its exquisite scenery, its five-star dining that was paid for by Federalist Society members and donors of the George Mason University's Justice Scalia School of Law. When NPR contacted Judge Eileen Cannon about the lavish trip she didn't disclose, what did Judge Cannon do? She blamed the court clerk and the court website and said, there must just be some technical issues taking place with the federal court disclosure website. And then all of a sudden, lo and behold, Judge Cannon's trips that she took and were funded for by donor money, sending her on lavish trips to Montana, were suddenly disclosed once NPR requested comment. That is who Judge Eileen Cannon is. And we've been reporting this, that on March 1st, you remember this? On March 1st, Judge Eileen Cannon held a hearing where she was supposed to hear oral argument. I mean, the people, Jack Smith and Trump's lawyers made these arguments. She was supposed to hear oral argument on the trial date, which was scheduled for May 20th, and all of the other associated dates in the case that were aligned with the trial date, to ultimately determine if there would be a new trial date and what the other dates would need to be set for this case. One of the things you'll remember in my reporting that I flagged, starting 9 months ago at this point, I was saying, look, this is a SEPA case, Classified Information Procedures Act case. And in SEPA cases, you set SEPA Section 5 hearings fairly early on in the process. In a SEPA Section 5 case, or a SEPA case with SEPA Section 5 disclosures, SEPA Section 4 issues involve the government withholding documents and replacing them or substituting them where there could be serious national security concerns and where the documents are not relevant or helpful in the defense. And there's a whole SEPA Section 4 process. But SEPA Section 5 involves the criminal defendant in a case involving classified information disclosing relatively early on in a case involving classified information the types of classified documents the criminal defendant wants to inject at a public trial, so there could be hearings to determine whether or not these documents should be made public in front of the jury, since they could significantly harm our national security interests. And one of the things that we always expected Donald Trump to do is engage in conduct called gray mail, which is a form of blackmail, essentially, where a criminal defendant says, if you don't dismiss these charges against me, I'm going to fight to make public our nuclear codes. I'm going to try to introduce our war plans. I'm going to try to introduce very sensitive intelligence on foreign countries, and I'm going to try to get a judge to allow me to do it. And federal judges are supposed to serve as guardians in these cases of the national security interests, but also being protective of the due process rights of criminal defendants. Also, any rulings by judges under SEPA Section 5 are immediately appealable rulings. So one of the things we've always been talking about here is that Judge Eileen Cannon refuses to make any real substantive orders regarding SEPA because she knows the moment she does and says, okay, Donald Trump, you can have this in public or that in public, that special counsel Jack Smith would go right to the 11th Circuit Court of Appeals, get her overturned, and get her thrown out of the case. So there's been this, you want to call it a cat and mouse game. I'm not sure who's the cat and who's the mouse or how I'd even describe it, but you have Judge Eileen Cannon not making substantive rulings, doing strange things with her schedule. But the strangest of all is you had that March 1st, 2024 hearing, right? The hearing was 3 months ago at this point. 2 months ago at this point. And Judge Cannon told special counsel Jack Smith that she was likely not going to accept the requested trial date of special counsel Jack Smith. Jack Smith said, look, Judge, you haven't set SEPA Section 5 hearings early on like you were supposed to. We suggested you did it early. You ignored us. There's no way trial's going to be able to take place before July. Let's set a July 2024 trial date. Donald Trump's lawyer said at the oral argument on March 1st, look, Judge Cannon, there's no way we can do July. You need to push this trial deep into 2025. Kick it out as far as you can. And Judge Cannon looked at special counsel Jack Smith and said, look, I think that your date's unrealistic. I'm more inclined to do Donald Trump's request and push this thing out. I'll give you an order. Okay, well, March passed. Remember, the hearing was March 1st, 2024. April passed. No rulings by Judge Cannon on the trial date. And then now we're in May. We're almost in mid-May, and Judge Cannon has kept the May 20th, 2024 trial date. Just think about that, just from a case management standpoint. Like what? It just shows you how unfit she is. I don't know. Maybe she's thinking about going back to that Montana Lodge. Maybe she's thinking about the food at the Montana Lodge, the great steak or the great pasta. Maybe she's thinking about the spa or the horseback riding that's being paid for by Federalist Society members. I mean, maybe she's thinking about the wining and dining that all of these wealthy donors were giving her that she wasn't disclosing. Maybe that's what was on her mind. Or maybe she was thinking about how she's going to help Donald Trump, probably, but she didn't even move the trial date. So here we are, 13 days from an actual trial. And here's the thing. We haven't really even seen a lot of filings from special counsel Jack Smith or even Trump's lawyers because I think they know the trial's not happening on May 20th. But how do you have zero shred of credibility that you keep the trial date on calendar for May 20th? You haven't reset the deadlines. You just issue a paperless order temporarily staying deadlines for Trump's SEPA Section 5 notice. Then you say you're going to follow up with an order setting a second set of pretrial deadlines for the hearing. That's what you're saying. And it's not even your second set. It's your third set. Remember, there was the first set. Then there was the second set that moved things to March. Then there was supposed to be a third set after March. So this is actually like the fourth set. And Judge Cannon hasn't done anything with the trial date. It's like, what in the world are you doing? What in the world are you trying to pull? Obviously trying to help Donald Trump. Now, if you're like, Jack Smith, why aren't you going to the 11th Circuit? One of the tactics that she uses is these paperless orders after paperless orders. We also don't know what the United States Supreme Court is with people like Clarence Thomas, who were also taking gifts from billionaires like Harlan Crow. Clarence Thomas taking like millions of dollars in gifts, going on lavish vacations and private jets. And You know, I think overall, when you just start thinking about it, whether it's Cannon or Clarence Thomas or all these right-wing justices and the Federalist Society, at the end of the day, these judges want gifts, they want a party, they want to live this lifestyle that, I mean, I've never thought of should be the lifestyle of judges who are supposed to stand by law and order, and they just make a mockery of our judicial system. Set a trial date. Just set the... You want to move it to 2025? Move it to 2025. I'll criticize you like you deserve to be, but at least you'll have set a trial date sometime. You're just going to leave May 20th with 13 days before trial, then do nothing about it, and then what, just leave the parties guessing when you told the parties you were going to make an order back on March 1st? After you already didn't even set the appropriate SEPA deadlines? It is absurd. And that's why when I criticize her, and you hear me do this when I criticize her, it's just like, you're just not doing your job as a judge. You're making a mockery of all these other judges by your behavior. You're tainting the entire judiciary, Judge Cannon, and judges like you. You are shameful to our legal profession. Despicable stuff anyway. We'll see what her second set of deadlines is. I'm Ben Mycelis from the Midas Touch Network. Hit subscribe. Let's get to 3 million subscribers together. Shameful, shameful.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the Midas Touch newsletter at MidasTouch.com/newsletter.